Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome all of you to this program on Islamic will with our guest, Sarah Adada, the lawyer from Ottawa. First of all, it is very much important to know that as Muslims living in 21st century, it's very much important that we have our wills. Our Prophet, peace be upon him, told us actually that it is a duty of a Muslim who has anything not to let 2 nights pass without writing the will about it. Not to let 2 nights pass without writing a will about it. It's essential. We never know what could happen. As Muslims, alhamdulillah, living in Canada, we do have access to many excellent lawyers, Muslim lawyers who do have personal experience of learning about Islamic matters related to their professions. And that's exactly how Sarah actually came to learn and be interested in Islamic will, through her personal connection with the family and questions specifically, as she said, related to their own family matters in discussions with her parents. And that's exactly what has inspired her, that she comes forward and basically be a contributing member of the community through her knowledge on Canadian law, where basically she's an expert in few of the areas, real estate, commercial contracts, will, and estate. She has got her education from University of Ottawa, our own city, Ryerson University as well, and she became member of Law Society of Ontario in September 2019. This, just for the purposes of logistics, this session would be recorded and it would be posted on different SNMC platforms for the benefits and interest of the larger Muslim community in Ottawa and beyond. Another point that is important also before we give mic to Sister Sarah, that Sheikh Mohsin would be part of this program as well. And if there is any question related to Sharia and Islamic will, he will be more than happy, inshallah, to assist. With these words, I would like to welcome our Sister Sarah Adada and thank her for being with us and contributing to the community via this presentation on Islamic will. Welcome, Sarah.
Thank you, Imam Zijad. I really appreciate the kind introduction, and I look forward to presenting this to everyone else. And of course, I look forward to your questions and to be able to help the community. And as Imam Zijad said, I've been a lawyer since 2019 when I was called to the Ontario Bar, and I've recently joined Korman Company. We are a real estate practice. But of course, we also provide services in wills and estates, commercial corporate law and contract review, and of course, family law as well, and other services included. And so to begin with my presentation, I also wanted to touch a little bit on our real estate practice. We do get into purchase and sale of residential and commercial homes, mortgage and refinancing assignments, and pre-construction contract review. And what I will do is that I am going to share my screen. Let me see this. And that way I will start my presentation. So the first thing I will say is that I will go through the breakdown of our presentation. So we will go over the terminology. What is a will and why are they important? What is the default distribution without a will in Ontario? The requirements of an Ontario compliant will, what are wills in Islam, why should you have one prepared, what are the components of a Sharia estate, where does the formula come from, an example of what happens, what are the types of provisions in an Islamic will, can the Ontario law come into conflict, and we will see why it can, the opening statement in an Islamic will, the benefits of having a lawyer prepare your will, what are power of attorneys and why should you have one. And we will also talk about the COVID-19 situation and how the Law Society is regulating the virtual signing of wills right now, since we have to maintain social distancing. And of course, lastly, we will look into estate planning and tools. Now, as for the terminology, Mirath means gross inheritance, all movable or immovable property left behind by the deceased. Warith would be the heir, a relative who may potentially inherit from the wealth of deceased. Wasi'a would be the will, so what we are discussing today, and is not something that's allocated during the person's lifetime, but rather to be allocated once they pass. Musi would be the one writing the will, such as the testator. Munfid, the executor, the individual chosen by the testator upon whose responsibility will be to make sure that the will is respected. Now, what is a will and why are they important? A will is a witnessed legal document that sets out the intention and wishes of an individual regarding the distribution of their estate following their passing. A lawyer can provide legal advice of one or more ways to minimize estate tax exposure. And in Ontario, the will can outline the following: how the funeral and burial will be held, which is important for us as Muslims in a North American jurisdiction. The appointment of an executor to make sure the individual's wishes are respected rather than it be court appointed. The appointment of a guardian for minor children rather than having it also decided by the court. Bequest to charity of the individual's choice, so it's a chance for us to do good. And including individuals who would normally not inherit under Ontario laws. So why have a will? As I said, I mentioned a few reasons as to why it's important. You know, you want someone to be appointed as for the, the guardianship of minor children, make sure that they are raised according to the way that you'd want them to be raised. Also the choosing of an executor, and of course the division of your wealth rather than it being only according to provincial laws and rules. Now, what is the default distribution without a will? In Ontario, according to the Succession Law Reform Act, if you have a spouse but no children, everything would go to the spouse. But if you did have children as well, then the spouse gets a preferential share of $200,000 worth of assets, or according to the Family Law Act, they may choose half of the net family properties. And the rest gets divided between the spouse and the children, such as if there's two children, the spouse gets 1/3 and the two children split the 2/3 equally. Without a spouse or children and your children left behind no children of their own, then your parents inherit equally, and if you did have grandchildren, then that grandchild specifically will get the share of their parent. Now, without a spouse, child, or parent, your siblings would equally inherit the estate or their children for their parents' share. Similarly, in the case of no spouse, no child, no parent, no sibling, then your nieces and nephews or the next of kin. And if none of the above, the government of Ontario inherits your estate entirely. Now, the requirements for an Ontario will, and you will notice that they're actually surprisingly very similar under Islamic law. Number 1, the testator must have testamentary capacity. The wishes are not the result of undue influence or duress exerted by others. So, which is actually why when we have clients come in to prepare a will for them, we make sure that it's only them that's in the room. And if they choose to have, let's say, a relative of theirs or a child of them with them in the meeting, we want to make sure that it's not that individual who's influencing the client to make certain decisions when drafting their will. The third requirement is the testator is the rightful owner of what he or she is disposing of in the will. Fourth, the testator understands and approves the contents of the will. We make sure before signing the will that we go over every page with you, every clause as well, that you understand it and you approve it. Lastly, the signature of 2 witnesses who do not benefit under the will. And of course, the actually very last thing is a safe storage for the wills that won't be difficult for the executor to access following the death of the testator, such as in a lawyer's office. So according to the Law Society rules, we keep them in a fireproof storage. Of course, you may choose to keep them with you. Some people keep them in a bank deposit. However, the issue with that is that the executor, when they want to access the will, they would have to prove that they are in the will, and that's difficult when it's in the safety deposit box in the bank. Now, what is a will in Islam? And as the Imam said in the beginning, as the Prophet Muhammad sallallahu alaihi wasallam mentioned, it is the duty of a Muslim who has anything to bequeath not to let 2 nights pass without writing a will. Sahih al-Bukhari. Now, the Islamic will needs to comply with the following four sources: the Quran, firstly, the Sunnah, Ijma, and Qiyas. Now, as we know, Islam is a way of life, alhamdulillah. It is a guidance from Allah subhanahu wa ta'ala that directs us through life and into the afterlife. Death is unavoidable and will come to every one of us. And therefore, we should not keep things for the unforeseen. We should get ready for them. Nothing in this world comes with us to our grave, and as a result, it does not belong to us to keep, and it becomes that of those that we are leaving behind, which is why it's important to have a will to ease the distribution according to Sharia law, and especially when you're in a non-Islamic jurisdiction such as Ontario. A man may do good deeds for 70 years, but if he acts unjustly when he leaves his last testament, the wickedness of his deed will be sealed upon him, and he will enter the fire. If, on the other hand, a man acts wickedly for 70 years, but is just in his last will and testament, the goodness of his deed will be sealed upon him, and he will enter the garden. With that said, it's an opportunity for you to help a poor relative who would not otherwise qualify for a share, or even to a non-Muslim because they cannot inherit under Sharia law. Now, why should you have a will prepared? Well, as we've seen, it gives you the peace of mind to know that your wishes will be carried out after your passing. It gives you the opportunity to do a good deed, and it can resolve and avoid unnecessary disputes that may occur between family members, especially during a sensitive time. And rather than having the Ontario government decide the distribution of your estate, which is, of course, does not follow Sharia law, and more importantly, the guardianship of minor children. More importantly, you do not want to leave things for the last minute. We even tell our clients to make sure that they get them done before they even travel, especially when they're leaving young children behind. Now, we will visit the two components of a Sharia estate. The first being the wasi'ah bequest, which allows for up to 1/3 of the estate to be allocated to a charity, a donation, or a person who would not normally inherit under Sharia. Now, of course, this is optional and depends on the circumstances. And lastly, the Sharia inheritance, which consists of the remaining 2/3, provides for the rightful heirs, the waritha, their rightful shares. And of course, that formula depends on the gender and the living members of the deceased. The distribution formula is entirely based on Sharia. And where the formula comes from is actually from Surah Nisa. Now, if you see from verse 11, 12, and 176, and it gives us the formula. So in verse 11, Allah instructs you concerning your children, for the male what is equal to the share of 2 females, but they are only daughters, 2 or more, for them is 2/3 of one's estate, and if there are only one, for her is half, and for one's parents to each one of them is 1/6 of his estate if he left children. But if he had no children and the parents alone inherit from him, then for his mother is 1/3, and if he had brother or sisters, for his mother is 1/6, after any bequest he may have made or debt. So most importantly, you want to make sure that you're paying off your debt. Your parents or your children, you know not which of them are nearest to you in benefit. These shares are an obligation imposed by Allah. Indeed, Allah is ever knowing and wise. And for you is half of what your wife leaves if they have no child, but if they have a child, for you is 1/4 of what they leave after any bequest they may have made or debt. And for the wives is 1/4 if you leave no child, but if you leave a child, then for them is 1/8 of what you leave after any bequest you may have made or debt. And if a man or woman leaves neither ascendants nor descendants, but has a brother or a sister, then for each one of them is 1/6. But if they are more than 2, they share 1/3 after any bequest which was made or debt, as long as there are no detriment. And this is an ordinance from Allah, and Allah is knowing and forbearing. And then, of course, there's also the last verse, which is 176. Now, from what we understand from these 3 verses, I will give you an example. Let's say this individual, a husband, left behind $10,000 worth of estate. The heirs are his father, his mother, wife, and his son and daughter. In this case, the wife will get 1/8, as we've seen. Each of the parents will receive 1/6, and of course, the brother receives twice as much as his sister. So the wife gets 1,250. Each parent receives 1,666. The son gets 3,611, and the daughter receives 1,805. And in another example, let's say this individual, a wife, left behind X amount and Y amount worth of property. The heirs are her two siblings, brother and a sister, both her parents, her husband, and her two daughters. And so in this case, you will see that her siblings do not actually inherit. Her husband would get 1/4, her daughters would receive 2/3, and they would share it equally, and each of her parents would receive 1/6. Now we will go on to the types of provisions in an Islamic will. We have mustahab, the favorable provisions, for example, when you're giving someone charity. The mandatory provisions, taking care of your debt and also taking care of the waritha, the rightful heirs. The hated provisions, so writing something that would obviously not be allowed and that would not be, appreciated by Allah. So for example, if you do not have enough to put in your wasi'ah and it's better for you to give it to the rightful heirs, then in that case, the wasi'ah bequest becomes optional. But if you still put it and you're putting the rest of your family in kind of constrained situation, it's not preferred, it's kind of makruh. And a forbidden provision would be something crazy like the serving of alcohol on your funeral day. That would be something, of course, forbidden. Can the Ontario law come into conflict? Yes, it can. So Part 5 of the Succession Law Reform Act says that it gives permission for the heirs to dispute your will if they find that you were influenced by someone in the family, or these were not your decisions. And of course, if you are, let's say, controlling the entitlement of, let's say, your children's share. So in a lot of wills, a lot of parents, what they will do is that they will make sure that the entitlement of their children is given to them upon their maturity. So let's say your child will receive half of their entitlement upon the age of 21, and then the remainder upon the age of 25. Now, of course, once they reach the age of majority, they can, let's say, dispute that in court. But of course, the last thing would be also Part 1 of the Family Law Act. If you remember in the beginning of my presentation, I mentioned how a spouse either gets the preferential share of $200,000 and a percentage, depending on the amount of children, but she or he may also claim half of the net family properties. So what happens in that case, it's as if you and your spouse had entered into a separation. Now, the opening statement in an Islamic will. I won't read it in Arabic because I might mispronounce something, but the way it goes in English is the following. I am the testator below. I recommend that I bear witness that there is no God but God alone, who has no partner, that Muhammad is his servant and messenger, and that Jesus is his servant and messenger, and his roll delivered to Mary and the spirit from him, and the paradise is true, and the fire is true, and that the hour is coming, there's no doubt in it, and that God sends those in the graves. I command those who have been left from my family and my offspring and all my relatives to fear God, reform the same, and obey God and his messenger, and recommend the truth and be patient with him. And I command them to do the same as what Abraham recommended his son and Jacob. And so this is optional. You could have this opening statement in your will, or of course you could keep it as a normal will would have here in Ontario. They wouldn't have an opening statement such as this. Now, the benefits of having a lawyer prepare your will is that we can make it a very easy process. We make the appointment together. We meet with you and your spouse to discuss your estate plan. What are your wishes? We draft the document and we meet again to have everything ready, signed, and duly executed. And then it is stored safely with us in a fire-proof box. The process appears objective and free from undue influence. So when you do have it prepared by a lawyer, and your trusted lawyer, of course, then it is hard for anyone to claim that you were unduly influenced or that it wasn't your actual true wishes. Thirdly, as lawyers, we will provide you advice to minimize tax exposure. So in Ontario, there are a couple of tools that you can use to minimize tax exposure, such as the way that you would put your name on the title of a property and what you would have under your wills and how your insurance works and so forth. The confidentiality and protection of your will is stored with your lawyer. We can cover the unexpected, and we act in your best interest. Now, we are powers of attorneys, and why should you have one? For those who are not familiar with power of attorneys, it's a document in which you designate a specific person or persons to act on your behalf on matters detailed in the power of attorney. And there are two types of power of attorneys. There's one for personal care, and there's one for property, and of course, a general power of attorney. So we know the general one, which is, you give someone the power of attorney to make decisions on behalf of you, whether it's in a board meeting or it's for the buying of certain properties when you're away. Now, for personal care, it relates to your health when you're in a situation where you cannot make those decisions, and the same thing for property, while you are incapable of making such decisions, or that a physician has declared you incapable of taking such decisions. Now, for the COVID-19 situation, as part of the Law Society's update, we can do intake through phone calls, Zoom, Skype, or FaceTime. This way we can limit our interactions with our clients while maintaining quality in our service and privacy to your affairs. But of course, for those that do feel comfortable to come in person, we just ask that you wear your mask and that we will maintain a proper distance in the meeting room. Now, the signing of the wills can be done virtually as well or in person, depending on what you're comfortable with and the safety measures put in place. And now, as for estate planning and tools, you can contact our office at any time. And once we are retained, we will send you a will questionnaire before our first meeting. And this will ease the process for you and get you thinking about what your wishes may be. And you can submit the form by email or bringing the form with you to our first meeting. Now, estate planning tools, we cover reviewing wills and power of attorneys if you already have some of them, explaining the estate administration process, what happens if you are chosen as the executor for someone's will. We can also help set up family trust, the reorganization of a business, estate freezes, and also estate administration, survivorship applications, and business succession planning, such as rollover or share purchase agreements if you have a corporation and you want to make sure that your children will be able to get it in ways that can save on tax. So this was the end of my presentation. If anyone has any questions, I am more than happy to take them in, and if there was anything that I wasn't clear about, I would be more than happy to clarify it.
Thank you, Sister Sarah. This is really useful, and I just want to ask, if you don't mind, because myself, I'm very new here to Canada, and I have heard from some of our congregation that if we don't have the will, the wealth or the guardianship of our children will go to state straight away, even if you have wife or children, something. Let me differentiate first. I mean, the wealth will go directly to, or state will take the wealth, even if I have wife and children. This is what I heard even 2 days ago from some of the congregation. And the other thing what about the ownership, the guardianship of kids, if there is no wife, for example? I know you have already made it, you have mentioned already, but if you can make it clearer, is there anything like this? The state will take my wealth, even if I have wife and children?
So no, what they may have meant is that the state, like the Ontario government, is that it would go through the court and they would divide the wealth according to the Ontario laws, the Succession Law Reform Act. So as I mentioned, the way it would happen is that if, let's say, you only had a spouse, you didn't have your parents around or no children around, then your spouse would get your estate entirely. But of course, if there were children involved and no will was written, then the way it would work is that your wife would get a preferential share of $200,000 worth of your estate, and the rest would be split between your wife and the children. Now, of course, when it comes to the guardianship of children, it's the same thing. Naturally, you would think that it would go right away to your wife. But of course, in some situations, it would go also through the court so that she may be appointed as the guardian for the minor children. And if she's not in the picture as well, God forbid, then the court would have to also go through it it wouldn't go right away, let's say, to your brother who would take care of you know, his nieces and nephews. So it just makes it a lot easier if you do have a will in place,
Yes.
because that way it's all taken care of, and you know, you're minimizing tax exposure, and you're also minimizing the stress of your family members in such a sensitive time to go through the court, to go through, you know, let's say a bunch of forms, and to, you know, meet on last minute with lawyers. And also, just to answer the question of one of the guests, is it acceptable to write the will by myself without a lawyer? It is acceptable. Of course, people can write their own wills. We just advise to at least, you know, consult a lawyer for it, just to make sure that what you're writing will be complied according to Ontario laws.
Thank you.
It's my pleasure.
Brother and sister, any other question? If you please would like to speak up, you are welcome, or you want to write it in the chat, please. You know, I have a question myself again. Also, if I know this is what we call forbidden wasiya in Islam, which is someone, for example, prevent one of his children from taking any share of his wealth, and unfortunately, this is happens sometimes. But if it happens and somebody wrote wasiya that to prevent, you know, one of his children from taking any share of the of his inheritance, can this child or son dispute this in the court based on the Sharia law?
So in Ontario, it would be difficult to dispute it under Sharia law, but they would be able to dispute it under Ontario law, because let's say, for example, let's say your son, he was dependent of you, let's say during your lifetime, then he could dispute it to court on the basis that, you know, nothing was left for him and he was dependent of you during your lifetime. So they could go on that basis. Also, to answer the guest question again, does the will require witnesses? Yes. So under Sharia law and of course under Ontario law, you would require 2 witnesses, and those 2 witnesses may not benefit from the will. So in that case, I would say your neighbor and someone else. And of course, at a lawyer's office, it's you know, usually the clerk or another lawyer in the office would be the witnesses of your will. Yeah.
Assalamu alaikum. We are like a group of 4 or 5 right here, and we have we have 4 questions to you. The first one is if there is like, you know, a husband and wife, and each one of them has a will, and both of them passed away. So which will happen first in a case like this? Or which will go through the husband's or the wife's will go or applied? I'm expecting that both of them have different wills, you know, at that point. The second question is if they assigned a guardian that doesn't live in Canada and he lives overseas, will he be able to come and take over for the kids and take care of them? Will Canada allow him for something like this, or what would be the procedure for this? The third question that we have is in case if there is a will, what is the procedure to change it in the future with the lawyer or outside? You know, the last question that we have is if we have like you saying it will be better if we have a copy or the copy of the will with the lawyer for safety and easy processing for it. So in case of that, I have 2 copies of this will, one with the lawyer and one with myself, like, you know, with my family. Is that okay, or if there is any issue with this? Jazakumullah kulla khair.
Thank you for your questions. If you don't mind, I'll answer the last question first. So, of course, we keep the originals with us in a safe storage, and we send you a scanned copy. But of course, we can give you a hard copy. We can, you know, print you another one. It wouldn't be the original, and you can keep it with you if you ever, you know, want to revisit it in the future and you want to look at it again and you decide that you want to change it. then you can contact your lawyer again and we can get that changed. Or what we would do is that we would also make sure that the old will that you already have is revoked through a clause in the new will. So generally what you will notice in a will is that we write a clause that says, this is the last will and testament, revoking any other that may have done in the past. Not in those exact words, it's a lot more fancy, but we have it something along those lines. And as for the guardianship of children for those that are overseas, I would actually have to answer you that question at a later time if you'd like. I will be providing my contact details at the end of the presentation, and I can actually review that with our senior lawyer, Safia. She was supposed to make it in today's presentation, but she had a last-minute meeting. So I will go over the guardianship of children. And you had two other questions in the beginning. I believe the first one was regarding if both the wife and the husband passed away at the same time and they both had wills, correct?
Yes.
Yes, okay. So they would happen simultaneously. What would happen in Ontario is that we also have a provision where generally one spouse would give the other spouse, a share. But of course, that clause is only valid if that spouse had survived past at least 30 days. So if they passed away at the same time, then the part for that spouse would be considered null and void, and it would just go on to the rest. For example, if you had that for the initial distribution would be your spouse, and then after your spouse, your children will get this percentage, and that percentage. So instead of your wife getting hers because of the situation, then it would just go straight to your children, and the same thing would happen to your wife. They would happen at the same time. There wouldn't be a conflict, but of course at that point, we would make sure that in your will that, because what happens is that a person will choose their spouse as the executor, and if their spouse is not surviving them at the time of their death, then the second executor would be chosen. It could be, let's say, your father-in-law, and the same thing when it comes to the guardianship of children. I hope I answered the questions clearly, and
Yep.
if I missed one question,
Thank you. No, I think you got them all. Thank you very much.
Okay, perfect.
Thank you.
Were there any other questions from the guest?
I just have one question, sister, that some people have some online will perform or whatever. What is the legal situation with them? Is it valid? Is it okay?
Absolutely. We are all free to decide how we want to design our wills. Us as lawyers, we recommend that you do it through a lawyer, only because we make sure we cover the unexpected. We make sure that there's going to be less disputes, and also it makes it seem much more objective for any other individuals outside of the will. So let's say your family members, if you were to make it on your own, or let's say you had someone helping you draft the will, tomorrow it could be disputed based on the fact that someone helped you with it. Let's say a family member, and they'll say, oh no, his son influenced him to draft this and that. But of course, if you are more than capable of writing your own will, and you know how you want to make it about, and you know that what you're doing is compliant under Ontario laws, which are quite straightforward, then you are more than okay to do your own will. But it's just most important to have two witnesses who do not benefit from the will.
Okay. And my last question is, a lot of people don't go to lawyer, I believe, because of the charges or fees, or they are too busy with their lives and whatnot. What are the fees? Is there any standard rate of fee for this process, or it varies from office to office?
It does vary from office to office. In Ottawa, the prices are not so different from each other. Right now, let's say in my firm, we have a special going on, a Eid special, $100 off, valid if you retain us before the 31st of August, 2020. And so In a lot of situations, it's usually a husband and wife that are coming in to get a will done. And so they want to get, let's say, a will for each one of them and also power of attorneys for each one of them. So a package like that is usually $950 plus HST. But of course, with the Eid special, it becomes $850 and you'd be getting 2 couple wills and also a power of attorney for personal care for you and your wife and a power of attorney for property for you and your wife as well. So our prices are not that different from what's out there in Ottawa. And of course, you know, we cover everything. We store it in a fireproof storage and we send it to your executor, God forbid, when the time comes.
And so this copy or the will, if it's not edited or changed, it will be with your office for maybe 10 years or until somebody passes or uses this will. Is that right?
Exactly. It could be with us for 30 years, for as long until the moment comes. And
okay.
then it does happen in a lot of situations that this is one thing. So once the will is drafted, we tell our clients to make sure that the executor or someone in the family knows that we were the chosen counsel for the drafting of their wills. That's that way. God forbid, when that time comes, they know who to contact to get those wills. So we also inform you that, you know, you make sure that your executor, the person that you chose to handle your estate, knows who to contact and where to find us.
All right. Jazakallah khair.
My pleasure.
You know, sister, there are 2 questions here on live chat on YouTube. I will read them to you. You know, I mean, the first one: can I only write in the will according to Sharia law? So there's no details of. I think what I understand, there's no details of the will, but they just want to write, you know, according to the Sharia law. That's it.
It is absolutely up to the person to decide what they want to draft in the will, so they can write that. In Ontario, it's not descriptive enough, so I would recommend to set up a formula to set up the distribution, and to also make sure that there are sufficient clauses to not just make it clear, but to also make sure that it's compliant in Ontario.
Yeah, okay, and yeah, thank you. The second question here: will my bank account be suspended, and how can a family pay for the funeral arrangement if it is?
Yeah, so what happens is that you will notice in a lot of wills, and you know, of course in Islam it's the same thing, is that the first thing that gets taken out of your estate is for any debts that you may have. Before anything is distributed to your spouses or to your children or to family members or to even a donation, your debts have to be taken care of. And as for the suspension of bank accounts, you know, that family member would have to get a death certificate presented to the bank to close the bank or to liquidate the assets.
Thank you. I think Brother Hamid wanna ask a question. Is raising his hand here.
Yeah, assalamu alaikum. I have a question regarding the guardianship again. And in the situation where both parents don't have relatives in Canada, so what is your recommendation in terms of guardian to be appointed to take care of the young children, as well as the executor in this case? What would be recommendation to select those person after the death?
So what I would recommend is having a discussion with that family member. Of course, in Ontario, we recommend that they do be Canadian residents. But for that question, I would actually have to get back to you on that, just to check with also my senior lawyer, because I actually have not faced something like that, thankfully. But what I will do is that I will actually give my contact details at the end of the presentation, and I would love to get your emails with those questions. And I think you raised your hand again.
Yeah, I have a second question regarding the in the case both parents pass away at the same time, and they do have joint tenancy, like the house and the bank account. So what happened in this situation when there is a death at the same time, and they cannot determine which spouse died first, and both of them, let's say they have a will.
They have a what?
They do have a will, or they don't.
Sorry.
Yeah.
So you mentioned something important, joint tenancy. So if they are holding their bank accounts or their properties in joint tenancy, it is tricky because when it comes to joint tenancy, there is the right of survivorship. And that is actually one way to also reduce tax exposure when it comes to your estate. But if they were to pass at the same time, then it would go directly to the estate, and it would not actually, at that point, if I'm not wrong, the way that it would work is see, it depends on who passed away first. Kind of a difficult question. But I will get back to you on that question.
Okay, thank you.
It's my pleasure.
I think there's a question here in the chat room as well, meeting room. Okay.
More detail. Is it possible to have many custodies for them in order? I believe you mean executors, like potential choices. If so, then yes. So it is possible to have, let's say, my first choice is an executor, my spouse. My second choice, my father-in-law. My third choice, my mother-in-law. My fourth choice, my eldest son, and so forth. You could. And yes, absolutely, they would be put in order as for priority.
I just have one question regarding the debts. You said the debts will be clear first out of the assets or will. What happens about the mortgage?
The mortgage, so it does depend if you're alone in that mortgage or not. It also does go through your estate. I think I heard it.
I didn't understand. Can you repeat it, please?
Yes. So it also depends if you are alone in that mortgage or not, and how you decided the payment for that to be. But it would also go through your estate, such as your children could be responsible for it, or also if you have an insurance put in place as well for that mortgage.
All right. Jazakallah khair. Thank you.
So, of course, if no one has any questions at the moment, and of course, I know that there was a couple questions regarding the guardianship of minor children if the guardians chosen in the will are outside of Canada. I would be more than happy to receive your questions on my email, and I could get to you as soon as possible. I will give my email on the chat. .com. Okay, so for everyone to see, and it's also it can be visited on Korman and Company, KormanCompany.com, where also my extension will also be provided.
Thank you very much, Sister Sarah. Any other question, brothers and sisters? Yeah, there's one here, sister. And,
yes, so you mentioned family trust. Can you speak more about what advantage we might have in doing so? So a family trust can also help to reduce tax exposure, and can also control the entitlement of the shares of your children. As I mentioned, I think in the middle of my presentation, is that you can have that in your family trust, that your son would get, let's say, 1/3 of their entitlement upon the age of 18, or it would be held in trust until the age of 25, and then upon the age of 30, they would get a certain amount of their share, and so forth. So that can also help the control of it. It can also reduce tax exposure. Those are some of the benefits of it. Another benefit of it, and let's see here. It would also reduce the tax exposure upon the passing, and it protects the assets, for example, especially against creditors. Is it possible to have the elder son to be a guardian if he is just above 16 years old? The guardian would have to be above the age of 18.
So, but you know, if he's 18 and this is should be you know, documented in the will, or you know, if both parents passed away and they left, you know, the older one is 18, can he automatically, you know, take the guardianship of his brothers and sisters, siblings, or it has to be written, documented in the will?
It should be written and documented in the will. If it's not documented in the will, then it has to go through the court. Yeah. An application would have to be made, and it could take some time. And during that time, it also depends on the court where they want the children to be until the decision is made.
So there's no, I mean, the best option for us is to document everything we want to avoid any issues.
Absolutely,
yes.
absolutely. This is why it's important to have a will. You make sure that everything is clear, everything is set out. That way leaves little to disputes and little to confusion or to interpretation by others.
Thank you. Any other question, brothers and sisters?
Yeah, I believe Hamid
Yeah, I have two other questions. The first one, can we appoint an executor outside of the Ontario province? Like, let's say, have a friend or someone in Quebec. Is it recommended to, or can we appoint this executor in my will? And second question, I think you mentioned a little bit about the succession law of Law Act of Ontario and
Yes.
the Islamic law. But let's say you have my will according to the Islamic law, but it goes it contradicts the Succession Law Act. Is it recommended that this? What is the recommended things to do in terms of distribution of wealth? Not to be in contradiction with the succession law and be in accordance with the Islamic law.
So in that case, that's why we do recommend visiting a lawyer. Is so for a lot of individuals, if you are more comfortable with drafting, setting up already, the clauses that you want, how the distribution happens, and then you can have a lawyer review that information and to let you know if that is going to be disputed, if that is allowed, and so on. So the thing is, when it comes to the Succession Law Reform Act here in Ontario, is that it also provides details as to how an individual can dispute some of these clauses. So especially if you're leaving behind someone, let's say your eldest son, who was dependent of you financially throughout your lifetime and is not getting as much as they would have hoped for or enough to survive on their own. So that would be one thing. And your question in the beginning as to if you were to choose an executor outside of the Ontario jurisdiction. So it is possible. However, they would have to give an estate bond. So it's something that can be time consuming and difficult and expensive if that executor is residing outside of the province or even outside of the country. But of course, it's up to the person to choose.
Okay, thank you for clarifying.
Yeah. Perfect. Were there any other questions from anyone, even on the YouTube live stream?
There's nothing else on YouTube.
Okay, perfect. Well, of course, as I mentioned, my email is sarah@kormancompany.com. I can be reached at any time with emails, and I will do my best to answer you all as soon as possible. And of course, you can contact us at our office And of course, even our Toronto office, where our senior lawyer, Sophia, is also there. And we can also help you set up a meeting if you want to retain us to do your wills and get all of that clarified. And of course, I want to remind everyone of the Eid special for $100 off if retained before the 31st of August, 2020. And also to remind everyone that we have the package deal for a couple will, power of attorneys for each, of the spouses, comes to a total with the discount $850 plus HST.
Thank you very much, sister. You explained everything very well. Jazakallah khair.
Thank you very much. It was my pleasure, and I look forward to doing more presentations for the South Nepean Muslim community if the occasion arises again.
Thank you very much, and would like to thank everybody for joining us today with this very important presentation and topic. Again, Sarah, it's really great to have you with us, and we look forward, to have you again in further presentations, inshallah azza wa jal. And if there's any more question, maybe we can just finish and conclude with dua, inshallah azza wa jal. We pray to Allah subhanahu wa ta'ala to ease the pain and suffering of every innocent person, and to make life easy for us, inshallah, and to make the last thing in our life is La ilaha illallah Muhammad Rasulullah. And may Allah subhanahu wa ta'ala bestow on us the blessings of these blessed days of the Hijjah. And may Allah Azza wa Jal open the door of Jannah and mercy to all of us, inshallah. سبحانك اللهم وبحمدك نشهد أن لا إله إلا أنت نستغفرك ونتوب إليك. بسم الله الرحمن الرحيم والعصر إن الإنسان لفي خسر إلا الذين آمنوا وعملوا الصالحات وتواصوا بالحق وتواصوا بالصبر. جزاكم الله خيرا all. بارك الله فيكم. السلام عليكم ورحمة الله وبركاته.
Salam everyone.
Okay,